That's correct, Your Honor. I mean, and that if
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm sorry. I mean,
Way the wrong answer.
I'm sorry, man.
Be set at a very high rate, determined by the court and or to remain revoked. These are three different violations of bond. He also has he has the no contact, he has the no go to that we have in this case, and so I don't understand what the reason that he needed to reach out for any reason.
Mr. Rich.
well, Your Honor, is the witness here? Because that is all. I mean, all the allegations are based on her words. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a
None of
hearing
the-
on this bond violation?
None of these phone numbers connect to his account. He absolutely denies the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged.
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well,
Right away, you can see the defense strategy taking shape. The attorney is emphasizing a critical legal principle: lack of evidence. In many criminal proceedings, prosecutors must eventually prove allegations beyond a reasonable doubt. But here's where things get complicated. This hearing isn't about the underlying criminal charges yet. It's about a bond violation, which has a much lower legal threshold. That means the court doesn't necessarily need ironclad proof like DNA or video footage to act. Instead, judges often rely on police reports, statements, or preliminary information to decide whether someone has violated release conditions. So while the defense is highlighting missing evidence, the judge may still consider whether the accusations alone are serious enough to justify revoking the defendant's bond. That distinction between proving a crime and enforcing bond rules often catches defendants by surprise.
You want a hearing on the bond violation?
absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. I'm also waiting for the actual screenshots of the text messages that are written in the Romulus police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
Now, in that police report, there are 6 phone numbers listed. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there. However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff's Department police report would be any different than this, as far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence. There's no third-party evidence. And frankly, if you read through the report.
I did. Before I revoked your client's bond. I did.
Okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie or he's the luckiest guy on the planet, because I would think that the Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m. He began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, started yelling through the window, and generated somehow, all while outside, 6 other phone calls from 6 different numbers, none of which line up to the defendant. If she's not here, Your Honor, then I think that is a very, very strong indication that this is not factual. The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Yeah. Well, you know, if that's the case, then shouldn't this have been a little higher priority? I think the prosecution knows that this is not accurate.
This is where the hearing becomes especially tense. The defense is pointing out what they believe are inconsistencies in the timeline. Multiple phone calls from numbers that allegedly don't match the defendant, claims of someone banging on doors and shouting outside an apartment complex, yet no witnesses listed in the police report. In court, Details like this matter because they shape how credible a story appears. But there's another factor at play here. The alleged victim isn't present in the courtroom today. That absence gives the defense an opening to argue the allegations may not hold up under scrutiny. At the same time, prosecutors often proceed with hearings even without a witness physically present, especially when police reports and statements already exist. So the judge now has to weigh two competing issues: the defense's claim that the story doesn't add up, and the prosecution's argument that the allegations still justify serious concern.
There's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report that says witnesses, none. Wait a minute, he's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? Without a witness, without some shred of physical evidence, there's nothing. This is just the allegations of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pre-trial where he's charged with child abuse force. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third degree. Mr. Vincent claims that he knew nothing about screenshots. Well, I just said on the record I don't have them. I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he didn't read that report. Also,
oh, Your Honor, I don't have screenshots.
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. Ms. Kirby, you may continue.
Thank you. I also explained in my motion that the Romulus police report is different than the two other contacts that this victim had with the sheriff's department. I've included those police numbers. Those are also in the motion. So I'm not sure what he means on, I have no idea why the sheriff's department and Romulus were here. No, it's completely different. And I don't have the accusations in those. I'm awaiting to get those, given that they're not in our county, and I followed the process to get those.
Now the prosecution shifts the focus to something the defense didn't emphasize earlier: the defendant's broader criminal situation. According to the prosecutor, this individual isn't just dealing with one case. He's currently out on bond for multiple charges, including domestic violence, child abuse, and resisting a police officer. When judges hear that a defendant already has several pending cases, it can heavily influence how they evaluate potential risk to the community. The prosecutor also explains an important legal concept here. Bond violation hearings don't require proof beyond a reasonable doubt. Instead, the court only needs enough evidence to reasonably believe the bond conditions were broken. That's a much lower bar. So while the defense is demanding concrete evidence, the prosecutor is reminding the court that the legal standard for this hearing is very different.
This is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and either adjourn so I can get the other police reports and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked and he to be remanded. Given the seriousness of this case and the seriousness of his other two cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this as serious at all, which also concerns me. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out with no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of the location that she does not want me to share out loud. I have no problem sharing that with the court. But she is not present, and regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing. Thank you.
Anything else, Mr. Benson?
And if hearsay allegations, someone's not here. This all happened in the last 48 hours, 72 hours.
Two things is not here, but if I look at what's in here, first of all, you're mixing two things. Because certainly they can proceed by hearsay as regards to bond violation. So that maybe we can clear that part up, because so they don't need her here for that. As to the final settlement conference, the people have stated to the court that they can proceed without her, if necessary, but that they also do know where she is.
I don't know how they could possibly proceed when there is not a
That's
snitch.
not your issue. They've made the representation to the court.
Okay, and I'm making a representation to the court that when you read the police report, which you have,
I read it.
then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availed himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond and today?
Just gonna come out the court.
Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm
way the wrong answer.
I'm sorry.
And this is the moment where the hearing takes a dramatic turn. The judge suddenly realizes that the defendant may have been told not to turn himself in after his bond was revoked, something that directly contradicts standard court procedure. When a judge revokes bond, the expectation is clear. The defendant must surrender to authorities immediately. If an attorney actually advised their client to ignore that order and simply show up later in court, that's a serious problem. In fact, it can even lead to professional discipline for the lawyer. Notice how quickly the judge's tone changes here. Frustration turns into outright anger. Judges rely on attorneys to respect court orders and guide their clients properly. When that trust appears to break down, it can escalate the situation very quickly.
I'll deal with this in a minute, because right now I'm furious, Mr. Vincent, that you would represent that client. Defendant's remanded. Take you. Court's going to stand in recess.
Please subscribe to help the channel.
This is Cameron Carter. Recall.
Now, Vincent, on behalf of the defendant. Yeah, there was absolutely a mix-up. And as much as my understanding was that he had spoken to the court and they did not tell him to come in, and I should have come in. Yeah, it's absolutely a mistake on my part.
Well, it's not only a mistake, it's a sanctionable offense. And I think you ought to know that. To willfully tell a client or even intimate to a client that they should in some way disobey a court order.
In no way, shape, or form, Your Honor, did I meant to have that effect happen. My understanding was that he had seen you in person this week and that you come to court from. I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. He is, I mean, I don't know, Your Honor. This is a horrible mistake, and I'll fall on my sword for it. But it is a misunderstanding. Not any, in no way, shape, or form was I trying to get him to avoid justice, and he certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week and that he was free to come here Friday. We clearly had, at no point did I ever advise Mr. Carter to do anything else other than follow the law. And it must have told him that a dozen times, something that every time I've talking to him, do not violate your bond, don't violate your bond, show up Friday. That's when we have a court date. My understanding was that was the understanding. And it is absolutely a snafu on my part. And I beg the court's forgiveness. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL so he can take care of his kids. He is working on another job. He's availed himself to court today, Your Honor. If this is bound over to...
Now the defense attorney is scrambling to repair the damage. He admits there may have been a miscommunication and even takes responsibility, saying he'll fall on his sword for the mistake. That's a dramatic way of acknowledging fault in the courtroom, but it also shows how serious the situation has become. Attorneys are officers of the court, which means they're expected to uphold legal orders, not create confusion around them. The lawyer is also trying to humanize his client by mentioning efforts to find work, attend counseling, and support his children. That kind of information is often presented in hopes that the judge might show some leniency. But once a judge believes a court order was ignored, sympathy usually becomes much harder to earn.
Jury selection, he'll be there then, too. Definitely. He understands this is serious, Your Honor. He's just vehement in his innocence, and I perhaps have been overzealous on my part. I meant no disrespect to you, the court, to the people.
What I'm going to do in this case, because, I mean, something's got to be decided as to what was told this defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until June 26th if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be my next one, August 11th. 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. Defendant's remanded.
Yeah, may I ask?
I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
Are we going to argue these other motions first, or are we going to, where are we with these 404Bs?
I believe Mr. Frykowski still wants to proceed on them, and I'm prepared to argue them as well.
All right. Guys, give me a few minutes and then I'll come back and I'll court stand.
What started as a debate over a possible bond violation quickly spiraled into something much bigger. The defense argued that the accusations were based on unverified phone numbers, missing witnesses, and incomplete evidence. Meanwhile, the prosecution stressed the seriousness of the allegations and reminded the court that this defendant is already facing multiple criminal cases while out on bond. But the most explosive moment came when the judge believed the defendant may have been told not to turn himself in after bond was revoked. something the court clearly viewed as unacceptable. In the end, the judge decided to revoke the defendant's bond and schedule a future hearing to fully address the situation. Cases like this highlight how seriously courts treat bond conditions and compliance with judicial orders. Even a misunderstanding can lead to major consequences in the courtroom.